Salutations, respected viewers. This is George from Ireland. I'm carrying on my series about English law, and this is about criminal. So I'm going to continue by talking about some of the major offences which quite often come up. Remember, criminal law, if it's a low-level offence and the sentence is likely to be 2 years in prison or less, then be dealt with at a magistrate's court, and about 97% of criminal cases are dealt with in a magistrate's court. Just occasionally, if the verdict is guilty, then the magistrate, or indeed the panel of magistrates, might refer the case up to the Crown Court because the magistrate's court's sentencing powers are insufficient to punish the felon. All right, so looking at malicious wounding, this is purposefully injuring someone with a weapon. So it's an attack on the body. It could be a knife or a blunt instrument and so forth. But it varies. Way back in 1999, there was a man in England who falsely claimed to be a physician, and he had these forged certificates, or he had a sort of medical degree from an unrecognised university, diploma mill, and he got away with for an astonishing long time, these patients coming to his none too clean clinic, because you just don't expect someone to lie about something that big. Who would have the impudence to claim to be a doctor when he isn't? And he gave them injections and things like that. And he was prosecuted for various things. It was fraud. Every penny he made from that was on a false basis, obtaining a pecuniary advantage by deception. But the injections he gave were malicious wounding, and he was successfully prosecuted for that. So if I deliberately stab you, even with a needle, even with your consent, lying to you, and you agree because you believe I'm a doctor, well, that's a crime on my part because you gave your consent because of my false pretenses. So it's interesting the way that this crime can be proven in a way you wouldn't initially imagine. All right, coercion. Supposing someone commits a crime, but he claims he was forced to do it by another, will this defence wash? This defence will only be effective if the person relying on it can persuade the court that he was in immediate danger of heavy violence. He was not going to get a mere slap, or it wasn't say, do this or I'll kill you tomorrow if he had a chance to run away. So the courts do expect people to show some fortitude and stand up to these threats rather than commit the crime. It can't just be psychological pressure or social pressure. You're shamed into doing it. You sheepishly go along with it. No, following the crowd is not a defence. That's not having your arm twisted into doing it. Now let's go on to sexual assault. This is touching someone's genitals, buttocks, breasts for the purpose of deriving sexual gratification against the person's will. There are obviously some valid defences, and then the case would never come to court if this was the purpose of medical treatment, hygiene, childcare. These are all permissible reasons for touching these areas, especially if the permission is granted. But supposing a patient was unconscious and a doctor or nurse was obliged to touch these areas without consent, that would be acceptable. Obviously little children, babies, they don't have to give consent, they can't, things like that. If somebody bogusly claims to be a doctor or nurse and touches the genitals or so on, this would still be sexual assault. The consent would be vitiated because the claim to be a doctor was false, and the victim wrongly believed the person to in fact be a doctor. What other things? Yeah, so any contact with the erogenous zones of someone under 16 is automatically considered to be sexual abuse unless one of those lawful excuses applies. Even if the person under 16 consents to that, that's still a crime because the consent will not hold at law. It's invalid. The person's consent just doesn't count. Even if they said they consent, signed a stack of documents, no. So there's a lawful excuse of honest belief. If someone over 16 has sexual contact with someone aged 13 to 16 and honestly believe that person to be over the age of consent, over 16 at the time, then the older person will be acquitted. So someone who's 16 or 17 will usually not be prosecuted for sexual conduct with someone aged 13 to 16. They're close enough in age. It's a Romeo and Juliet law. Usually, they have to judge it on these circumstances. They might say, well, this boy was 17, the girl was 13, or even she was 16, which is unusually immature blah, blah, blah. He plied with alcohol first. Any of these things would make the Crown Prosecution Service say, you know what, we're going to prosecute anyway. If a boy was sent to prison for kissing a girl aged 15 with her permission, that would be unduly harsh. But strictly speaking, it is against the law. Any consensual sexual contact, even between people aged 15, is mutual indecent assault. So look at positions of trust. An adult in a position of trust is not permitted to have any sexual contact with someone in his charge under 18. As in 16 and 17-year-olds, normally they're allowed to engage in romantic liaisons. They can get married at 16 with their parents' permission. You can get married at 18 without your parents' permission. So in Scotland, you can get married at 16 even without your parents' permission. So these teenage lovers from England would run away to Gretna Green, the southernmost station in Scotland, and get married there, sometimes in the blacksmith's smithy. I'm not sure why the blacksmith could marry them, but anyway, having married them at 16 in Scotland without their parents' permission, they returned to England. Was that marriage legally recognised? Yes, surprisingly, even though such a marriage would be illegal as formed in England because they were under 18 and didn't have parental permission. Because it was legal in Scotland, perhaps surprisingly, when they left Caledonia, returned south of Hadrian's Wall, it was held to be legally valid. So coming on to this positions of trust, a parent, stepfather, stepmother, a teacher, doctor, nurse, dentist, police officer is not allowed to have sexual contact with someone under 18 who's in their charge. Now, the stepmother and stepfather situation doesn't have to be married couples only. If a man or woman is living in a relationship with a parent of a minor, he or she is considered to be a stepfather. Okay? So let's say someone called Anne has a boyfriend called Lewis, and Lewis has a son. Anne cannot have a sexual relationship with that 17-year-old son, Lewis. Okay? She's the girlfriend of the father. That would still be assault. This is all set out in the Sexual Offences Act 2000. So coming on to drugs, well, there's a Control of Drugs Act. There's quite a lot of legislation banning particular chemical formulas. So drugs are permitted for anything other than medical use. It would be a misuse. This includes heroin and cocaine. Surprisingly, until the 1920s, there was a completely free system on this. It was anything goes, a free-for-all. You could go in and buy it recreationally from a pharmacy or elsewhere. Read, read Sir Arthur Conan Doyle, Sherlock Holmes taking heroin just for kicks. Because we say we're a free country, and it's bizarre how the way things have gone. What's more restricted, what's less restricted than it was in the 19th century. So possession of drugs without this license is a crime. So in any hospital, you will find cocaine and its derivatives. It was invented by an ophthalmologist, for Pete's sake, a German doctor invented for eye operations to stop excessive bleeding, to numb pain, all the rest of it, from the coca leaves of South America. So in hospitals, it's given for operations to stop too much bleeding in the nose or elsewhere. And they're versions of heroin, opiates, to palliate severe suffering. It can be a drip into your arm, things like that. But can make people hallucinate. They can control it themselves on a drip to regulate their suffering when they're suffering from cancer, particularly if it's terminal. So supplying illegal drugs is a crime. If drugs were given for free, it's still supply. All right, you could sell it, you can give it away gratis. That's still supply. That's why it's called supply, not just selling. If someone possesses more than a certain amount, there's a presumption that it is for the purpose of supply, not for personal use. Because trifling amounts for personal use is a less serious crime, possession, rather than supplying it. So there are all sorts of other things which are forbidden. They're Class A, Class B, Class C, depending on how harmful they are. Won't go into that too much more. All right, kidnapping. This is taking somebody against their will. This abduction is a crime, whether it's for ransom or not. So that's that. Coming on to false imprisonment. So that's preventing someone having a reasonable way to leave a place, locking them in a room without their consent. That would be false imprisonment, because there's obviously lawful imprisonment, which the authorities are permitted to impose after a conviction, or holding someone on a remand, that's whilst they're awaiting trial. Now, if there's a way to leave the place you put them in, but it's not safe, that's still false imprisonment. You lock someone in a room without his permission, but there is a window he could climb up that is very high and dangerous to get out of. You could say, well, I haven't confined him completely, he could get out the window. No, it's still false imprisonment because it's not safe. Or there was a case where some guy took a boat, landed on the landing stage. They wouldn't allow him out until he paid the fare. He refused to pay the fare. He eventually caved in and was let out. He tried to have him prosecuted for false imprisonment, but it didn't wash. All right, terrorism. This is defined by the Terrorism Act. Any terrorism is unlawful violence anywhere on the globe for the furtherance of any national, political, religious, or other ideological cause. So it's a crime to engage in that. So if you're doing it simply to gain money, that's a crime, but it's not terrorism. Robbing a bank, you're using unlawful violence or the threat of violence. But because it's not ideological, it's not terrorism, it's just armed robbery. So violence for the advancement of any of the causes outlined is a crime. Furnishing finance for the purpose of furthering that violence is also a crime. Providing such arms, intelligence, surveillance, providing logistics, inciting others to do any of the foregoing, all this is a crime. Any of that's a crime defined by the Terrorism Act. Note that terrorists set off bombs. The bombs could kill someone, and that's murder even if a warning was given, because you knew the bomb could go off, you knew it could easily kill people, you're reckless to that fact. So you gave a warning, but so what? You shouldn't have set off in the first instance. Now, sometimes these bombs went off and didn't actually kill anybody, and there was a warning were given. So could you charge them with attempted murder? Some people thought, well, that might not wash because they might be able to appeal successfully because they didn't actually try to kill anyone. They did give a warning. Or so a new offence was created in the 70s, causing an explosion with intent to endanger life. Even if you didn't intend to actually kill people, you knew there was some sort of chance that it would kill people. The bomb disposal officers could come to try and defuse the bomb, and they could have been killed. So that was that. So terrorists often say they don't want the bomb to kill anyone, and they inform the authorities. They give it's in a certain location due to explode at a particular time. But such a warning could be inadequate, garbled, deliberately misleading. The bomb might go off earlier than initially planned. Setting off a bomb in a town is indisputably risking life, despite the warning. Otherwise, there'd be no need for the warning. Right, the criminal process. So I'll give you an example. Imagine Terence is arrested on suspicion of theft. He's taken to the police station, he's fingerprinted, and his DNA is taken. Even if he's acquitted or no further action is taken, that will probably be kept. You can apply to have it destroyed, but they usually don't do it. One of the rare cases they did was when Damien Green, a Conservative MP, was arrested over something. A duty sergeant is responsible for his custody. You can be arrested by a constable, the lower rank in the police, but duty sergeant is ultimately answerable. Terrence is checked to see he's healthy. Is he fit and well? The police must make sure he doesn't die or come to serious harm in custody because they are responsible for him. The police can hold Terence for up to 24 hours. After that, they must either charge him with a crime or release him. If they do charge him with a crime, they'll probably release him quite soon anyway, because theft is not very serious. And a trial would come up in the magistrate's court, be a month or two away, and he's not a danger to the public. He can wait the trial at home. When you're arrested, your wallet, your mobile phone will be taken away. Sometimes your shoes and socks and things like that, so you couldn't find anything like a belt, so you couldn't hang yourself. They don't want people to commit suicide in custody. So that is that. Pretty boring. So you'll be given food and drink every so often. The police wish to question Terence. A solicitor is provided for him free of charge, while the police question him. If it's late at night, the solicitor may not be available. The police can say to Terence, okay, we can hold you overnight and question you in the morning with a solicitor. Or you could waive your right to a solicitor, agree to be questioned right now, and when the interview is over, we'll set you free. So Terence is keen to go home, so he waives his right to have a legal counsel there and goes ahead and is questioned without one. He has to sign that waiver form. The police questioned him. The interview is sound recorded, so there can be no dispute of what was said. Until the 90s, this wasn't always done. There were notes taken, shorthand notes. People said the police often falsified things, verbaled people, claimed that some confessions were made in the back of the police car, things like that. It's a fair cop gov. In Cockney slang, that would mean, you caught me, I am guilty, sir. The interview is not always filmed, and some people say, oh, that's bad because the police could be intimidating the person. Police don't shout, they don't act menacingly. They're not even allowed to stand up in the interview lest they be accused of trying to scare him. They've got to see he's fit and well, verify that to go ahead with the interview. If he feels sick, they'll end the interview until he feels able to continue. Some people say, I'm so ill, and roll around the ground. They have to end it. So Terrence can refuse to answer questions, just not even open his mouth. They can't force you to say anything. He can simply say no comment to particular questions. Imagine he answers other questions. He's not obliged to say a word. However, if he fails to answer some questions, it could undermine his defense later. Were you in that shop? And he refuses to answer. At his trial, he says, no, I wasn't in the shop. Well, that's not very credible, because you should have said that at the time when you were first interviewed. The police tell them they have eyewitnesses that they saw him commit the theft. That's a lie. Are the police allowed to lie to suspects? Yes, they are. So the police tell Terrence, we know that you did it, and you can help yourself by confessing. So some people will be tricked by this and do it. If there's a burglary, first thing they do, the two people say separate them. They come and say, by the way, the other guy told us everything. And he's actually blaming it all on you. And often a suspect will say, what? Be outraged by the betrayal and say, no, that's not true, he did it. And they testify against each other. They're allowed to lie to you. Terrence denies the crime. The police feel they have sufficient evidence despite his denials, CCTV or something. They charge him with the crime of theft in relation to a television stolen from a van. After the interview, he's released on police bail. So they let him out, he can go home. The police send their file of evidence to Crown Prosecution Service. After they've charged him, they're not allowed to question him again. Sometimes they release you without charge, could charge you at any point later in the future. They could release you, ask you to come in voluntarily to be interviewed again. You could refuse. They can arrest you again. That's quite difficult. Have to get a warrant, special permission from the judge to show they've got a fairly good reason to arrest you again. The Crown Prosecution Service, anyway, will look at the file. They could choose not to prosecute if they believe it's not in the public interest to pursue the case. They also have to see there's a reasonable prospect of securing a conviction. If there's a trifling chance of a conviction, don't bother. In this case, the CPS decide to prosecute Terrence. He's contacted, told the trial date. He's told to contact a solicitor. He gets legal aid, gets set for free. The criminal defense solicitor is from a company specializing in work of that nature and doesn't pay a penny for it. The solicitor is called Usha. Usha informs him that he must tell the truth. If he tells Usha that he committed the crime, then she will not lie for him. That'd be unethical. She'll be banned from the profession. She will not defend him on the basis that he didn't do it if he says that he did. Anyway, if he informs Usha that he did commit the theft, then she can defend him on the basis that it was a mistake. He's very sorry for what he did. He was financially desperate. It was a first-time offence. No real harm was done. He'll return the item. He had a difficult childhood, so plead mitigation. But no, Terrence maintains his innocence. Usha does not believe him, but she's entitled to defend him anyway. It's quite often the case. He says he's innocent, so we'll go with that. She doesn't know he's guilty. She just suspects it. She's allowed to do this. It's up to the court to judge his guilt, not her. Terrence is told not to go abroad at this time, and indeed his passport is confiscated. So he shows up on the appointed day at the magistrate's court. The 3 lay magistrates hear the case. These are respectable local people. They're educated and they have no criminal record. The magistrates do this on top of their normal jobs for no pay. One of the magistrates is a teacher, another's a dentist, another's a pilot. They can belong to any profession, but these 3 professions would be typical of stipendiary magistrates. Not stipendiary, of the lay magistrates. JP, Justice of the Peace. He's asked to plead not guilty or guilty. He pleads not guilty. There's a brief trial. The officer who arrested Terrence testifies. The policeman swears in the Bible to tell the whole truth, nothing but the truth. There can be no casuistry. You can't mentally reserve things. Anyway, he does not keep quiet about anything that's relevant to the case. The policeman can't do that. The prosecution question the police officer. The defense solicitor is allowed to question him as well. So Usha does not manage to shake the testimony despite cross-examining the solicitor. So a woman is cross-examined. She's a Muslim. She swears on the Quran. The police show some CCTV footage. It's quite grainy. The prosecution solicitor reads out some interview testimony that Terrence gave to the police and the fingerprint evidence. They must read out the entire interview, not just a portion of it. Terrence chooses not to speak in his defence, which he's allowed to do. But therefore, Usha, his own solicitor, can't interview him either. He must be questioned by both sides or neither. You can't be questioned by just one. The trial takes a couple of hours. The magistrates go into another room to discuss the case. After a few minutes, they come in and they all agree that Terrence is guilty. They all go back. There's a guilty verdict. They then announce the sentence, 12 weeks in prison. The court officers take him down immediately and handcuffed him. He's taken to prison. If he'd pleaded guilty, he would have been found guilty immediately, but it would reduce the sentence by 1/3. He would have been given 8 weeks instead of 12. All right, I'll stop there.